For those of you who have not met him yet, he is a longtime resident of Golden Valley, and he's been an attorney for more than 40 years. He ran his own firm for 35 of those years and is currently with the law firm of Meyer Njus Tanick. I hope I'm pronouncing that correctly. He's a graduate of the University of Minnesota School of Journalism and Stanford Law School. Marshall has won numerous awards over the years. He was also a prolific writer and frequent contributor to the Star Tribune opinion page and to our local Sun Post paper, among others. You may have seen some of his articles. They're always interesting. He's also a history buff, and we are the beneficiaries of that when he comes to talk to us about some of the aspects of the law that may particularly affect Minnesota. So today we are delighted to have him back to give a look at what he calls 9 for 9, another momentous year at the Supreme Court. So please welcome Marshall Tanick.
Thank you very much. Happy to be here. Pleasure to be here. Two quick happy ones. My grandson, who lives in Washington, D.C., was in town, as he usually is this summer, 2 weeks ago. Loves the park, Schaefer Park, because that's a French Schaefer Park, and I know Rotary's contribution to the park there, Schaefer Park. Loves it, goes there every day, makes me run the 40-yard dash with him and all that stuff, and happy mark. Secondly, as I've told Billy, I fell off my bicycle this weekend, and fortunately I had my helmet. Always wear your helmet. Didn't fall on my head, but I bruised my knee, but I'm okay. I'm fine. I fell on my knee, and oh geez, I'm going to break something here, but I didn't. I'm fine. I'm bruised, but I'm here. Okay, how much time do I have? So 1:25 or so?
No,
1:15, okay. You're going to hear the abbreviated version. This is kind of a long one. This year's Supreme Court, past year, 2023-24, has been characterized as tumultuous. And the previous year was characterized as tumultuous. And the previous year before that was tumultuous. Every year is getting tumultuous. So I'm going to cover some of the more significant and interesting and important rulings from the last year. I call it 9 for 9, but it's really 9 different topics more than cases. I'm not going to cover all of them. I'm going to skip. But if I had enough time, I'd cover all that, but I don't. For those of you who want the longer version, if you go online, I'm doing this for lawyers, but it's not real technical, but for lawyers and other law groupie types, on October 8th for the Ramsey County Law Library online Zoom. So if you hit Ramsey County Law Library, you'll see some promotional item about it for October 8th, noontime, but they're giving me an hour and a half to do it. Here I only have a half hour, so this is going to be a truncated version, but happy to do it anyway. Quick thoughts about the Supreme Court to begin with. The Supreme Court, back when I was in law school, ages ago, used to hear about 200 cases a year. Do I need a microphone? I guess I do for the recording. Okay, sorry. When I was in, I'll stand here. When I was in, is this okay? When I was in law school years ago, the Supreme Court used to hear 150 to 200 cases. It kind of diminished over the years. It went down to below 100, then to 80, 70. And last year, the Supreme Court, consistent with its recent history, heard 60 cases. And so that's that's the lowest level of activity of the court in many years, maybe forever. There's about 8,000 cases the Supreme Court gets about 8,000 requests a year. About 1,000 of them are relatively insignificant. Some of them are prisoner cases, pro se cases. I'm not saying they're not important, but they kind of dispose of those. There's about 7,000 significant cases that are presented to the Supreme Court, which has total discretion on what cases to hear. It took 60 last year. Help me with the math here, 60 out of 7,000. So your chances of having a case heard by the Supreme Court is less than 1%. So the next time you hear someone say, I'm going to take that to the Supreme Court, they ain't. Or they might, but they have one chance out of 100. What kind of cases does the Supreme Court hear? What causes them to hear a case? Exercising it's their discretion. Certainly significant cases, one that have national importance, one that are pressing and needs immediate response, that's one factor. Another factor, though, is if there's what's called a split in the circuits. If there's a number of cases decided by lower courts that have different results in similar cases, they will step in and try to clarify the law when there's different decisions. that split and come out in different ways. Another factor is what cases they've heard recently. They will try to balance cases. They'll hear an environmental case one year. They'll hear one time they'll hear a criminal case, a couple of death penalty cases, defamation cases, employment cases, constitutional cases. They try to mix up their agenda a bit, so it's not necessarily the case that the most important cases get heard, but it is the case that the cases that are heard tend to be important because they form so-called precedent for future cases. So I'm going to look at a few of them here from the past year, and I've also passed out a little summary sheet there if you want to follow the Cliff's Notes version. Okay? There were two major abortion reproductive rights cases decided by the court this year. I'll take that back. They weren't decided for reasons I'll get to. They were heard but not decided. One of them was the mifepristone case. That's the abortion pill case. 60% of abortions are conducted by pills, pharmaceuticals, not in the traditional medical offices, and that percentage is going up. Mifepristone is the most widely used form of pharmaceutical. It's a mail order. It's done by mail, and it's been approved by the federal government, the FDA, since 2000. A group of anti-abortion doctors challenged the 20-year history of the use of mifepristone, and they claimed that it was illegal to distribute those or dispense those by mail, and they challenged the Federal Drug Administration to ban that.
This is your fault.
Yeah, it'll stop. It'll stop. Just let it go.
But what do they keep calling back?
It'll stop. And the group of anti-abortion doctors challenged the FDA's allowance of the pill to be sold, to be dispensed. The court that came to the Supreme Court last year, and the Supreme Court dismissed the case on grounds of standing. The court did not decide the case on the merits. The court said that these doctors did not have a right to bring this case because they weren't recipients or even prescribers of the medication. The doctors' claim is that they all claim to be quite pro-life, anti-abortion, and they said that the fact that women can obtain abortion pills bothers them and causes them great emotional distress. That was their claim. And the court said, well, that may be the case, but we don't hear cases just because people want us to hear them. The doctors had no standing to pursue the case, and therefore the case was thrown out and the pill is still available. However, interestingly, in the court hearing, two of the judges, Judges Alito and Thomas, raised an issue, although they didn't decide it, about something called the Comstock Act. Some of you may be familiar with the Comstock Act. It's an 1873 law passed by Congress 150 years ago, and it was a law aimed at preventing the use of interstate commerce in the mails to ship and transmit pornography and certain medical devices, including abortion devices. It's been on the books for 150 years, and it's never been used against any medical device or any medical pharmaceutical. It has been used sporadically against pornographic magazines and pornographic videos, but even that's pretty slim. But it's never been used. However, Justice Alito and Justice Thomas suggested that the Comstock Act, which is still in the books, could be applied here to ban the use of any kind of abortion pharmaceuticals. The court didn't decide that, but they at least suggested that it might come back again before the court. In Project 2025, which you may have heard of, the 900-page epistle that forms at least a basis for some prospective legislation in the Trump administration, if President Trump is former President Trump is reelected, that the Project 2025, the blueprint for a next Trump administration, specifically says, among its 202 directives, that the courts should, that the law should be enforced, and the new administration, if it's a Trump administration, may start enforcing that law that would effectively ban more than 60% of all abortions nationwide. They haven't done it yet, but it's in the wind because of this case. But for the time being, pharmaceutical abortions are allowed. Another abortion case that was interesting was an emergency care case. This is a case out of Idaho. Idaho is one of 16 states that have very restrictive anti-abortion laws. There's more than 16, but there's a far extreme. In fact, Idaho's law is the most extreme. It's no weeks, no nothing. The Idaho law is no abortions, period. Rape, incest, no abortions, except to save the life of the mother. And I said that carefully, not the health of the mother, the life of the mother. In other words, in Idaho, you can't get an abortion unless you're dying. That's the Idaho law. There's a federal law called EMTALA, Emergency Medical Treatment Law Act. Under the federal law, any hospital that receives federal funds, which is just about all of them, any hospital that gets any kind of federal funding, or Medicare, Medicaid, and they all do, must provide emergency care. And emergency care is defined broadly. If someone breaks their arm or breaks their leg or suffers a wound or is in a car accident, the hospitals have to take care of them under the federal law if it's a quote emergency. The federal government sued Idaho and said you have to perform abortions if there's an emergency situation, regardless of the death of the health of the mother. If it's an emergency, you have to perform it. Idaho says no, we don't allow abortions unless someone's dying. That issue went to the Supreme Court, so the Supreme Court had to reconcile the Idaho law, which is no abortions, versus the federal law, which says you have to provide abortion care if there's an emergency. An emergency is defined broadly. Emergency basically means if the woman wants it. The court then had that issue decide which one prevails, the Idaho no abortion law, the federal you have to do it law. It's a very significant case, obviously, because 16 states have laws almost like Idaho or very close to it. So it doesn't just affect Idaho. And the court decided not to decide. The court's decision was, well, the evidence in this case is a little bit fuzzy. We don't have enough evidence either way. So the court punted, sent it back to Iowa and said, you guys figure this out. We'll see you in a couple of years. So that law is still hanging out there. The Idaho law is still valid, but it's under question now, and we'll see how that happens. What occurs there, but obviously political considerations are going to play a big role in deciding in how those cases resolve themselves. And depending upon the complexion of the court and other factors, a couple of years from now we're going to see both these cases come back before the court, and maybe I'll even make a presentation about it. I think I'll mention this case because it's important. This is kind of in the weeds here, and I don't want to get too deep into the weeds, but it's called the Loper Bright Enterprises case. There's a legal doctrine called the Chevron Doctrine. And pardon me here if I get too complex, but the Chevron Doctrine, which has been around for a long time, is a legal doctrine that says that regulatory agencies have the power to regulate businesses that are before them or licensed by them. Environmental Protection Agency, the Federal Aviation Authority, the Federal Trade Commission, the FCC, Federal Communications Commission, all these vast administrative agencies at the federal level, let alone the state level, where we have the PCA, EPA, all these different agencies, they regulate businesses. And the courts for years have allowed them to do so. However, in this case, the court said no more. The court ruled that the Chevron Doctrine essentially says that administrative agencies have broad discretion in regulating businesses that are within their domain. The court said from now on, the Chevron Doctrine is no longer valid, and any administrative agency any business can challenge any administrative regulation by going to court. And when they do that, of course, the administrative regulation is going to be impeded, not in effect. It's going to be held in abeyance pending a court suit. Those court suits take 2 to 3 years. So any business that wants to contest a regulatory agency decision can pursue that through the federal court system and postpone any kind of regulation for years. That's the upshot of this case, and we'll see how it plays out in a couple other cases. It's a really significant case because so many actions taken by government are regulatory agencies. Congress at the federal level does very little. They're at an impasse, of course, and because of the split in the partisanship, it's very difficult for Congress to do much of anything these days except name post offices. But the federal regulatory agencies are the ones that do most of the action. But under this ruling, they can still do what they want. They can still take action, but anybody can challenge that by going to court and starting a new case all over again against the agency. It really is a significant boon to businesses being able to challenge regulatory agency decision making. And here's an example of it. This is a Securities and Exchange Commission. In this case, the Supreme Court threw out essentially the internal system by which the Securities and Exchange Commission regulates security markets. The Securities and Exchange Commission oversees licensing of brokers and financial advisors and other people involved in the financial industry and can penalize them for business fraud, wrongdoing, and the like. The court in this case said they can't do it anymore. The court ruled that the Securities and Exchange Commission does not have the authority to impose sanctions on people who violate the securities laws. Instead, all those cases have to go through the court system. Effectively, that emasculates the Securities and Exchange Commission. So when you hear or read about security fraud cases or manipulation of the market or any kind of business fraud, that used to be controlled by the Securities and Exchange Commission. Right now, because of the Supreme Court decision, they essentially are diluted, their authority is diluted. It's an example of how the Supreme Court has really impeded the regulatory industry, the regulatory administration. One more case and then I'll move on. Here's another regulatory case. This is a labor case, National Labor Relations Board. That's the federal agency that regulates management labor relations in the private sector. And it provides, it referees disputes between management and labor, conducts elections for union elections, can penalize employers who are violating labor laws and the like. And it's been around since 1937. It's one of the New Deal agencies, and its domain is labor law. For years and years, forever, the NLRB has had the authority to intervene in labor disputes if there's reasonable cause to do so. In this particular case, Starbucks, a number of Starbucks facilities have been, baristas in Starbucks facilities are trying to organize. In fact, that's a big push by labor unions these days. Labor unions comprise about 10% of the workforce. That's half of what they were 20 years ago, and half of that would be what they were 40 years ago. So where labor unions comprised about 37% of the workforce several decades ago, 40 years ago, they now comprise 10%. There's a lot of reasons for that, including the way we work today, the technology, remote work, the lack of manufacture, the diminution of the manufacturing base in the traditional labor organizations. But most of the efforts by labor unions these days has gone into trying to unionize low-paid fast food workers, hospitality industry, and the like. I'm not deprecating those folks. I'm just saying they're at the lower end of the wage scale. That's where the unions have made their biggest strides. Starbucks is an example. There have been Starbucks has had 6 elections over the years for unionization. 3 have won, 3 have lost, but it's a real hot topic for unionization. In this particular case, Starbucks was accused of interfering with union activities because they fired some of the activists in the union. They fired them because they were trying to organize a union. The NLRB stepped in and prevented them, or tried to prevent them from doing so, because there was reasonable grounds to do so. That case went up to the Supreme Court, and the Supreme Court elevated the standard for assessing employer interference with union organization. The NLRB ruling said that before the NLRB can investigate an alleged violation of their labor laws, before they can do so, they must be able to show that they're likely to succeed. In the past, in order to investigate labor violations, the NLRB had to have some reasonable basis to do so, some facts that support it. Now the Supreme Court has said you can't investigate labor violations unless you can show us that you're likely to succeed. That's kind of like the Vikings-New York Giants game coming up this Sunday, in which they say, Vikings, you can't go on the field unless you can show us that you're likely to win. Because the Supreme Court's telling the NLRB you can't pursue an investigation unless you first can show that you're going to prevail in the investigation. It essentially guts the ability of the NLRB to investigate labor violations, and that's again an attack on these administrative agencies. It's a very serious issue for labor management relations, and it's an important one. Yes.
Assuming there was the will to do it and the votes to do it and so on, is there any legislative way to put Chevron back in place?
Yes, but it would take legislation, which would take a majority in the House and 60 votes in the Senate.
Yeah.
The Senate doesn't act on things without 60 votes, and that's why, as I said before, they don't do much. They did pass the infrastructure law, but Senate doesn't do much these days, and maybe in a long time in the future, if you can think of how can they get 60 votes on one side of the issue, that's why naming post offices is a big deal for the Senate these days. Even that's hard sometimes. Gun cases, there are a number of gun cases. I'm just going to touch upon a couple of them. This one most people are familiar with is Garland versus Cargill. No, that's not our Cargill, okay? It's not. It's just a person named Cargill. Garland is Merrick Garland, the Attorney General. Cargill was a person who pursued this case. He was a bump stock owner, and it was financed by the NRA, National Rifle Association. This case dates back to the Las Vegas shooting. Remember the mass shooting in Las Vegas? 2018, a fellow went in the 23rd floor of the Mandalay Bay Hotel. Below, in the parking lot, they were having a country music concert. He killed 57 people with a rapid-fire shotgun, which was armed with a bump stock. I'm not a gun person, but I understand that bump stocks essentially turn rifles into machine guns. He was able to get out. He injured 200 people, killed 57 within the space of 90 seconds using this high-powered bump stock that was applied to his firearm. As a result of that, the Trump administration, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, another administrative agency, enacted a regulation banning the use of bump stocks. Now, you can't take a bump stock, it's a device that you can attach to a gun, and turn it into effectively a machine gun. That was a ruling endorsed by former President Trump in the wake of the Las Vegas shooting. That was challenged by the NRA through a gentleman named Cargill, and it went up to the Supreme Court, and the Supreme Court overruled that agency and said you can't do that. You cannot extend the prohibition on machine guns in the law to bump stocks. That can only be done by congressional legislation. The agency cannot define or characterize what kind of guns are permissible or not permissible, even though they've been doing it since 1938. Machine guns have been outlawed in this country since 1938. But the court said, well, that may be the case, but you can't do that anymore unless Congress passes a specific law. So there you go, name a post office or pass a law. But the agency is not allowed to determine what kind of firearms can or cannot be used as a result of this case. So it wasn't a Second Amendment right to bear arms case, but it was a case that essentially limits the regulation of firearms at an administrative level unless Congress acts. Important case. Here's another case. This was a marquee case this year by the Supreme Court, United States versus Rahimi. There's a federal law that bans possession of a gun by an individual who has a domestic abuse order out against them. Many states, including Minnesota, have their own state laws, but it's a federal law that was involved here. Rahimi was an individual who had a domestic abuse order restriction, an HRO, harassment restraining order type thing, order against him in Texas for assaulting his female partner. 3 weeks later, he ended up assaulting another female, and the police were called to that scene and got it resolved. But while they were at the house, they found that Rahimi had a gun there. And they said, Rahimi, you're the guy who has that domestic violence order here. You can't have a gun under federal law. Rahimi says who? They say, well, we do, because the law says you can't have one if you have a domestic violence order against you. Well, he took that up to the Supreme Court, and the Supreme Court did uphold that. Many people thought they wouldn't because of the right to bear arms under the Second Amendment, but nonetheless, Chief Justice Roberts wrote a decision that said it was permissible for a federal law to prohibit gun possession by domestic abuse violators. So in that sense, the NRA lost that case because the case was brought on behalf of the NRA. It's one of the few times that the court has ruled against the NRA, but there's some other cases still going through the court system that are sorting out what is permissible and not. A Minnesota case was decided last month that said that the Minnesota state law that bars ownership of guns by individuals under 21 years of age. It's a Minnesota law. That was thrown out by the courts on the grounds that it was violating the Second Amendment. So there's still a lot of Second Amendment litigation going on. About the only regulation that has been upheld in recent years is this one against domestic violence abusers. I'm going to skip down a couple here and get to the Trump cases here. There's a lot of other cases, but I want to talk about the cases. There were 4 cases during the past term that involved directly or indirectly former President Trump. One of them was the January 6th case. This is a case that about 1,500 people have been accused of January 6th violations of law. About 1,500 people, 585 have been convicted either by pleas or guilty verdicts by judges or juries. There's still about 1,000 cases still swirling through the system, including several from Minnesota. But these are January 6th Capitol rioters, and one of the main charges against them was something called obstruction of official proceeding. There's a federal law that makes it illegal under federal law to obstruct a federal proceeding. That law was passed in 2002 during the Enron scandal. Some of you may remember that. It was the Enron scandal, business scandal, fraud and business fraud, securities fraud. And at that time, Congress passed a law that made it illegal to obstruct an official proceeding. One of the charges against many, but not all of the rioters, was that they violated the Sarbanes-Oxley law by obstructing the official proceeding, which was the certification of the election back on January 6th. That case got to the Supreme Court, and the Supreme Court threw out those charges. They said that charges can't be brought because the Sarbanes-Oxley law was a business fraud law. It involved doctoring business records, shredding documents, lying to Congress, business fraud. And they said this, even though the law refers to obstructing an official proceeding, they said the certification of the election was not an official proceeding under the Sarbanes-Oxley law. The charges were dismissed against about 200 of the rioters. They weren't all charged with that, but about 200 of them will have their convictions reversed or their charges dropped. Two of the 4 charges against former President Trump in the election interference case being handled by the special prosecutor Jack Smith, 2 of the 4 charges are this. They're not part of the case anymore. So half of the case against President Trump, even though he wasn't a party to this case, half of the charges against him are being dismissed because the court said that you can't sue him for obstructing an official proceeding under the Sarbanes-Oxley Act. So it has some effect on narrowing the claims against President Trump, former President Trump. Now we get to 3 more Trump cases. This is kind of an interesting one, don't have a lot of time, but this again, he wasn't a party to this case. This is a trademark case. A Democratic activist and a marketing guy in California produced T-shirts that have the name on the front, Trump Too Small. What that refers to, some of you may remember, some don't, in the 2016 Republican primary campaign, one of the significant public policy issues that was part of that primary was the size of President Trump's hands. Marco Rubio said he had small hands, and on one of those debates that Trump participated in, Trump shot back and said that Marco Rubio has small other body parts. And they got into a bit of a debate during the debate over the size of their various anatomical parts. It actually happened during a debate, okay? So that the marketer then started selling these T-shirts that said Trump Too Small. The trademark office sued him and said you can't use Trump's name in a trademark. You can make all the shirts you want, but you can't you can't trademark T-shirts with his name on it because the only person who can get a trademark is the person whose name it is. So Trump could sell Trump Too Small T-shirts, but he can't because of violation of trademark laws. Not a very important case, but kind of a fun case. These cases are less fun. Trump versus Anderson is a ballot ban case. It seems like it was years ago, but it was only last year. At this time, several states sought to prohibit former President Trump from being on the ballot. That was last year at this time. Minnesota was one of them, as you may recall. In Maine, the basis for those claims were the insurrection clause of the 14th Amendment to the Constitution. That's one of the Civil War amendments. Following the Civil War, 3 amendments to the Constitution were made. One was the 13th Amendment barred slavery. The 15th Amendment gave people the right to vote regardless of color. It wasn't enforced for 100 years. And the 14th Amendment, among other things, were the Equal Protection Clause, the Due Process Clause, and Section 4 of the 14th Amendment provides that if a person has been involved in an insurrection or aided and abetted an insurrection, they are prohibited from holding federal office. The law was basically directed to Confederate office holders and Confederate, high-level Confederate military leaders who were prohibited from holding office because they were involved in an insurrection called the Civil War. That clause was applied in some cases, tried to be applied against former President Trump to keep him off the ballot. Minnesota was 4 states, it came before 4 states. Minnesota punted on it. The Minnesota Supreme Court said, well, we don't know, it's too early yet, this is November of last year. We'll have to wait and see if he even gets on the ballot because he hadn't been endorsed then, or nominated even. So Minnesota didn't decide that. Michigan said you can't keep him off the ballot. Colorado said you can, and so did Maine. That case went up to the Supreme Court, and the Supreme Court overruled a ban on Trump being on the ballot under the insurrection clause. The court said you cannot use that clause to keep someone off the ballot unless Congress passes a specific law naming that person. They did a couple of those back after the Civil War, like Jefferson Davis, the president of the Confederacy, but the court said that's not sufficient. You have to have a specific law passed by Congress to keep someone off the ballot. So former President Trump evaded or avoided being knocked off the ballot in those states and other states as well. That happened last year at this time, but it's interesting history. And lastly, we get to the big one. This is the immunity case that everybody knows about. Trump versus United States. The issue in the case, that case, it was the election interference case in Washington, D.C. It's not the Georgia case, which was kind of slumbering to a conclusion maybe. It's not the Mar-a-Lago documents case. It's the election interference case in Washington, D.C. against former President Trump. The lower court, two lower courts have ruled that he's subject to criminal prosecution for his activities and behavior in connection with January 6th and the events leading up to January 6th. He's being charged with criminal behavior. He has claimed he's immune, which means he can't be charged with criminal behavior. The two lower courts said he could be charged. They haven't made a decision yet. They just said the charges are applicable to him. The case came before the Supreme Court, and the Supreme Court reversed the lower courts. Chief Justice Roberts wrote the decision, and he said that a president has immunity. Immunity means you can't touch him. You can't pursue criminal charges for official activities. You can pursue criminal charges for unofficial or private conduct. The court did not define what that means, but the case was sent back to the lower courts to decide whether some or all or any of the former President Trump's activities in connection with January 6th or thereafter were official or unofficial. If they're unofficial or quote private, he can be subject to criminal prosecution. If they're official, he can't be. And that issue is percolating through all of these cases against former President Trump, including the hush money case. Of course, he was convicted in the hush money case, but his lawyers have gone back to court now and saying, well, that was official conduct, and therefore he should be immune. And some people are saying, well, wait a minute, what's official about having sex with a porn star before he was even in the White House? Well, the checks he wrote to her, he wrote in the Oval Office at the Resolute desk and sent them to Michael Cohen. So Trump's attorneys are now arguing that that was official conduct because he did it while he was president. So we'll have to wait and see how that plays out. But those are, and there's more litigation forthcoming. But that is the key case that sets basically stands for the proposition that a president cannot be charged with criminal offenses for official conduct. And official conduct, at least so far, has been defined as conduct that involves authorized activities of the president dealing with any duties that he has or any activities he undertook while he was president or in the White House. We'll have to see how that plays out. But that's the end of my presentation. I hope you found it interesting and informative. I'd be glad to take any questions, comments, criticisms, or concerns. Lay low on the criticisms.